This judge runs a tight ship. Watch how she balances strict compliance with real-world fairness. Do you prefer tough love judges or second chances judges?
All right, this is Leah Chavez, 22T1470. Good morning.
Good morning.
All right. And then probation is here on this one. All right. Okay, probation, want to tell me what's going on with Mrs. Chavez?
Yes, Ms. Chavez. Well, I'll tell you what I'm gonna recommend, that we close it out unsuccessfully.
Okay, so looks like she did not submit to 26 UAs.
Correct.
She didn't get her treatment done. And she missed probation appointments. And she didn't report to sober living. Okay? And so you just want me to close it out with
With jail.
with jail.
Yes.
Okay? All right.
And we have an agreement with the DA to revoke and close this unsuccessful with 60 days jail, and that's what Ms. Chavez would like to do today.
60 days with all of that. And this is the first?
I believe it is.
She's looking at up to 364 days of jail. She did not stay in communication with probation. She didn't do UA, which tells me she probably was under the influence. She didn't do any treatment. I mean, honestly,
Quick legal note, probation isn't a free pass. It's a contract. It's the terms UA's treatment. Check-ins and the court can revoke and impose a jail sentence within the original range. Actions meet consequences.
have we figured something out?
Yes, Your Honor, I've spoken with Ms. Graham and Ms. Chavez, and we've come to an agreement to revoke and close unsuccessful with 300 days jail.
With who?
300 days.
That works. The court is accepting your admission to your violation of probation. The court is closing out your case unsuccessfully with 300 days of jail. Good luck to you.
Great question for the comments. Should repeated known compliance over years still qualify for light time? Or does leniency lose its logic after the 10th misstep?
Yes, because they get in your career. You sure you don't want to get representation?
Yeah, I get representation. Yes, bro.
Okay, because I'm looking at you, and the reason I'm saying this to you, sir, is because my father was an officer in the military, and he was over a lot of airmen, and things like this can get you in your military career if it goes the wrong way for you. So I think you should probably apply to the public defender's office at the very least and find out if you qualify. Okay?
And there it is, 300 days after a fast recalibration. Translation: negotiations live and die on credibility with the bench. When a judge signals too low, smart counsel adjusts fast.
Why did they do this case too? 25F5162.
I don't know.
I gotta understand why the division didn't handle all of her DD cases and wrap them all in deferred.
Your Honor, it's because they moved the case from the district court to here.
That makes zero sense to me because Division 1 should have handled all of her DD cases. All of those cases that she got the deferred sentence on were DD cases, probably involving the same victim. So it makes zero sense that she had a public defender, probably in felony court, that didn't get this case wrapped in with the other cases. That makes zero sense to me.
I'm not sure if she pled guilty.
She did plead guilty.
I don't know if it's a deferred sentence or not.
So that's what I understand. Like it's
Soundbite of the day: mess around on probation, find out. This is why defense attorneys harp on doing every requirement early. It keeps doors open later.
to me, it makes zero sense that she pled guilty on 3 DB cases literally this week, and they didn't take care of the last one.
I agree. And the notes say that we're on notice to address bond today in this case, in county court. I don't know.
This just doesn't make any, and is it the same victim on all 3 cases?
Yes, Your Honor.
That's incompetence.
I'll talk to the DA in that division.
That's absolute incompetence on both sides. Miss Woolton got screwed over.
We agree.
This is my branch.
Self-repping in a criminal case while in the military pipeline. Risky. A conviction can derail careers, security clearances, and duty assignments. Pro tip: get counsel, get clarity.
To get her life on track, away from her family, and kind of start over. And jail would set her back in that progress that she's been making. I also believe jail is not warranted. I understand the jury found her guilty, but at the end of the day, this case was about a voicemail. She's not charged with and not convicted of a violent crime. And it seemed to have arisen from an argument over her daughter's care, who is now 18 years old and a legal adult. So I believe conflict over her daughter's care is unlikely to repeat itself since she's legally able to care for herself. In particular, I did not hear her say anything, any kind of threats about killing her mom, and I was sitting there in the hallway with her.
Courtroom logistics lesson. Related domestic violence matters are often bundled for consistency. When they aren't, you get conflicting outcomes and a judge calling out incompetence. Yikes.
Person, but then she just, anything sets her off, and it's a nonstop situation of calls, voicemail, text messages, not only to me, but to her own daughter, degrading, disrespect, threatening, disrespecting, threatening our lives, threatening my children's lives who are 8, 7, and 2. I work from home, and my husband's always scared to even leave because then it's like, how am I supposed to protect when I'm not there? So
Driving without a license isn't a minor. Oops, stack enough of those and the next stop can be custody. Audience check. Should judges jail first or escalate fines and classes longer?
Usually takes at least 10 months to do the treatment that she was, actually more than 10 months. And she got level 2 and 86, which makes me think that this was not a first DUI.
This was a 2022 case, so this one's been going on for a while.
So the 22 case, we're now in 3 years later, and we're gonna give her 60 days when she had essentially almost 3 years to get this done. I would commit a DUI if I could only get 60 days and I didn't do anything, and I didn't know UAs and I did nothing.
Sponsor, segue, but real talk. Data breaches raise identity theft exposure. Legally, states have disclosure laws. Practically, you still freeze your credit. What's your security habit freeze? Lock or vibes?
On what Ms. Taylor said, I think help is really what her family was hoping for. So I think mental health is more appropriate. I believe asking for jail at this time after we went to trial is something of a trial tax in this situation. And so we are asking for just the probationary period and the mental health evaluation.
Yes, Your Honor. I just pulled up the defendant's record. She has 2 guilty pleas and
Courtroom decorum 101. Juries notice everything. Eye rolls, mutters, side talk, any of it can affect sentencing, tone, and, in extreme cases, contempt findings. Silence can be strategic.
Couple of conversations I need to have. My first with you, Mrs. Walker. Ms. Walker, you have to control yourself, okay? You cannot have these outbursts that you're having. I'm trying very much not to pay attention to you because I fear that if I pay attention to you, that I will draw attention to you that I don't want to draw, okay? The jury is watching. You need to control yourself, okay?
Prosecutor asks for remand plus probation with evaluations. That bundle says, immediate safety plus long-term rehab. Question for you. Is short jail plus treatment more effective than long probation alone?
For a long time.
I understand. Now,
I will find you be, don't talk. I'm talking. I will find you be in direct contempt of a court order. And I will bring you in on contempt charges. And you will stay in custody. You understand me?
Victim allocution moment. Courts weigh safety and impact, not just punishment. Comment below. A victim asks for help, not jail should the judge follow that wish.
If you cannot control yourself, Miss, I understand, Ms. Walker, I understand. Ms. Walker, I understand. Listen, Ms. Walker, I understand that this is highly emotional for you and there's a lot of emotions going on with you. But I am requiring for you to control yourself. If you cannot control yourself, then I will have to use other means. And I do not want to use those means to control you, okay? So, you're gonna have to control yourself.
Trial tax claim flagged. Clarifier. Judges can't punish you for going to trial, but they can consider post-verdict conduct. criminal history, and risk when setting sentence terms.
Everybody have a seat. Let's have, then our next.
Yes, Your Honor. The people would be asking for the defendant to be remanded today for 60 days. Then we'd ask for 1 year of supervised probation with a mental health evaluation and substance abuse evaluation. We'd ask for the defendant to comply with the recommendations from both evaluations. The defendant's behavior since the verdict over the last 15 minutes.
Plus supervised probation and treatment, then the judge offers weekend jail to protect employment. That's a mercy lever. You only get it if you keep cool.
Has been very concerning to the people. The defendant, I heard her say she said fuck, shit, goddamn 1,000 times. Not 1,000 times, but probably close to 100 times. She was yelling in the hallway. I asked counsel if they needed assistance with the deputy to help keep her under control. They said they didn't. She called the victim a bitch. She said, fuck that bitch. She also said, thank God my mom isn't here because I would have killed that bitch. The defendant's disrespect for this court and lack of remorse is concerning for the people. The victim is concerned for her own safety after this verdict. And so we'd also ask for a no contact order between the victim and the defendant. We are very concerned for the victim's safety and for the safety of this family.
Okay. And then,
Offer withdrawn. Courtroom rule. When the judge is solving your problem, don't talk yourself into a worse one. Do you think judges should ever rescind leniency mid-hearing?
what's her criminal?
A controlled substance F4, and I think she has a couple of misdemeanor convictions within the state. I can pull them up real quick, but I looked at them earlier today.
All right.
She has several charges for, sorry, let me look it up.
All right. And Mrs. Taylor, did you want to address the court in any way as the alleged victim? You can come on out. The deputies are here, so you're safe.
Honestly, I just want my sister to get help. I don't want any contact with her or have her close to my home or anything like that. I just want her to get help and to stay away from me.
Direct versus indirect contempt crash course. Direct equals in the judge's presence, instant ruling. Indirect equals outside the judge's view, requires separate process. Here, behavior kept crossing the line result. Custody now, arguments later.